66-year-old widow Hattie Leith lived in an isolated country home at the end of a long dirt road in rural North Carolina. Her grandson, Wayne Darnell Bumper, lived there with her. Unbeknownst to Miss Leith, her grandson had become the primary suspect in a rape case. 2 days after the crime was committed, the county sheriff, 2 of his deputies, and a state investigator went to Miss Leith's house looking for their suspect, Darnell Bumper. The officers met Miss Leith at the front door where she had been busying herself with some housework. Some young children peered at the officers from the shadows of the home. One of the officers said, "I have a search warrant to search your house." Miss Leith simply answered, "Go ahead," and opened the front door. Very soon thereafter, officers found a rifle in the kitchen that would prove essential in bringing about Darrell Bumper's conviction. Here's the thing about the search warrant. It didn't exist. The officer only said he had a warrant. He didn't read it or show it to Miss Leith. In her own words, she said, "He was the law and had a search warrant to search the house. Well, I thought he could go ahead. I believed he had a search warrant. I took him at his word." When the government seeks to rely on someone's consent to justify the lawfulness, the reasonableness of a search, it has the burden of proving that the consent was freely and voluntarily given. The government's burden is not discharged simply by proving that the offended party submitted to the government's claim to some lawful authority. So here we are. Can a search be justified as lawful if it rests on the grounds of a consent that was granted only after the official conducting the search claimed he had a warrant that did not exist? It didn't take the Supreme Court very long to conclude that under these conditions, no valid consent can exist. You see, whether Hattie Leith consented in this case or not is really beside the point. It's more important to note that whether a search warrant existed or not. When an officer of the court states their authority to search a home with a warrant, the announcement is, in effect, a warning to the occupants that they have no right to resist an intrusion. This warning infers coercion, even if it's colorably lawful coercion. If you don't stand out of the way, force is going to be used. And where there is coercion, the Supreme Court found that there cannot be consent. If the officers had only stated they would apply for a warrant if their request to enter was denied, a valid consent could have been created. But an officer's claim that he has the tremendous legal authority of a search warrant in his coat pocket when no such authority exists brings with it the coercion necessary to spoil any consent obtained on that doorstep. And the story of the Fourth Amendment continues on. My name is Mike Scanlon, and this has been a FLETC Talk.